Good afternoon, everybody, and welcome to another webinar in our series of webinars for activists, I should say. So today we have Suki Hackett, who is going to deliver a webinar on discrimination, LGBTI discrimination. So this is as I said, one of the series of webinars that we've been providing that the training committee have asked us to do, particularly for our caseworkers. And I know there may be some of you in the audience who are not a caseworker, but if you are, this webinar will form part of your accreditation as long as you have logged on in the usual way. It will also be available on the website for other people to watch, but for accreditation purposes, you need to register and log on in your own name so that we can record that you have watched the whole webinar, and it will then count as part of your caseworker accreditation. So I hope you all enjoy this webinar. Suki is very experienced from the legal team. She will introduce herself on all forms of discrimination. So with that, I will just move over to Suki, and thank you for joining.
Jennifer. Thank you, Jennifer, and thank you for the introduction. I have enjoyed writing this webinar for you. I hope you enjoy it too. And we'll make a start. I'm just going to share the PowerPoint that I've prepared and talk you through it. And I think you can see it now. I'm just checking that I've loaded it correctly. I will say from the start, IT skills are not my strongest point. Hopefully the discrimination law that I share with you will make more sense than my IT skills. But let's make a start. Terminology. I felt that this was important to start on this point because terminology is changing, it's fluid, and terminology is not set. It's not set for an individual. They may have different terminology they used to be referred to as. So I've tried to set it out the best I can based on what the legislation states, but also taking into account what the LGBTI community expects as well, because at the end of the day, they are who we're trying to look after and protect. So you'll see from the slide, I am saying that the LGBTI is a collective term that is used by the NASUWT when referring to transgender, lesbian, gay, and bisexuals. I've already mentioned that it is fluid and changes, but we will work with the terminology that I've used, which is from a legal perspective, because we're talking about LGBTI rights in the workplace. And the term LGBT is sometimes extended by adding Q for queer or questioning, A for asexual, or I for intersex, or more generically, simply A+1. Moving on to the next slide. Again, remaining on the point of terminology, I've tried to set out some terms that are used more often than others. It's not an exclusive list. There will be other terminology, but I thought it would be beneficial to just set this out at the start because it will make more sense when we work through the training pack in terms of why I'm using certain terminology. We're starting with assigned gender, which is gender assigned at birth based on physical attributes. Gender fluid, people who identify with no particular gender, may also refer to themselves as trans or transgender. The term is used interchangeably, depending on how a trans person or transgender person feels comfortable. Transitioning is where a person who has decided to live permanently in the acquired gender. Acquired gender, affirmed gender is a trans person's gender after transitioning. Binary, a person who associates with a gender associated at birth as either male or female. Dead naming is the reference used for a transgender's birth name when they have changed their name as part of their gender transition. Intersex is a naturally occurring variation of human development with the appearance at birth as neither clearly male or female. Cisgender, identifying with their birth gender. Gender critical refers to a belief that sex is immutable and binary and that people cannot change from that. Moving on to legal terminology. So this is leading up to the path of the Equality Act. Sexual orientation covers lesbian women, gay men, heterosexual and bisexual people. I think there is a bit of a misconception that heterosexual people are not covered by the legislation. And then transgender trans is commonly associated with those people whose gender identity does not correspond to the gender assigned to them by birth. We've talked about terminology. There is various terminology that we would not use when we talk about the LGBTI community. Phrases such as preoperative or post-operative focuses on anatomy rather than gender identity. We would clearly not be using those phrases. Gays, a gay is considered derogatory. A lesbian or gay woman, some lesbians are very happy to be referred to as gay, others do not like to be called gay because they have a distinct identity that is not the same as gay men. So again, the reason I'm spending so much time on terminology is important that we try and get it right the best we can, but a lot of this will come back to how a person wants to be referred to. Again, homosexuals, ahomosexual are phrases that we don't use. Dyke queer, the same. Although, interestingly, a study done by Stonewall have cited that queer is being reclaimed by younger people who do not identify with traditional categories around sexual orientation and or gender. And it's also used in various arts and cultural movements. But my view is that we should stay away from that terminology as it can be seen as derogatory. But Stonewall is an organisation that campaigns for LGBTI rights. They're very informed, but that is, again, a view shared by them. Right, so again, just still talking about legal terminology, it should not be confused. So sexual orientation should not be confused with gender identity. Gender identity refers to who you are, while sexual orientation refers to who you're sexually attracted to. And what we have is the gay community and the transgender community share similar experiences in terms of discrimination, and they've joined forces, and this is why we talk about LGBTI rights. So looking at LGBTI discrimination, unfortunately, there is daily bullying, pressure on them coming out. Many studies have provided shocking statistics in terms of discrimination that they are facing. The TUC study, where they actually describe the results as shocking, which is where I get the phrase from, have reported that 68% of the LGBTI community is sexually harassed at work. That is a very high statistic, yet only two-thirds did not report the discrimination that they are facing. 1 in 4 of those state they don't report the discrimination that they face for the fear of being outed. And they're also concerned about the impact on their own mental health. Once they're outed, it is a process with any kind of litigation. It will have a strain on a person's mental health. And if they're not feeling supported, it is a particular concern to the LGBTI community. Others have decided, well, 16%, according to the TUC research, have actually left their role rather than deal with the unlawful discrimination, which is quite telling in terms of how they feel, or how they feel they're not supported. And they also, the study showed that they fear for, there are concerns about reprisals, the impact on their career development. Everybody works hard to develop their career, and they would rather not say anything and have that impact on career progression. Other studies have been carried out, similar studies with similar reportings by the CIPD, which was 2021. 55% of trans workers face conflict in the workplace in the previous 12 months. And when we talk about unlawful discrimination, the assaults are very serious to the extent it can include rape. So the work that we do in raising awareness and putting in support for the LGBTI community is crucial for us as the union, that we want to support such members. The NASUWT have carried out their own member survey, which found that more than half of the LGBTI teachers, 52%, experienced discrimination and abuse from pupils and parents. So it's not just an employer form of discrimination, it can also, well, it is also part of how they're treated by students, pupils, and how parents may not support the LGBTI community. The NASWT survey also revealed that 52% of members have seen no improvement in the level of abuse in the last 3 years, with 27% stating that it has actually got worse. So, as I say, they are concerning statistics. Okay. So, I've set out on this slide the law as it was, just looking through that. Same-sex sexual activity between men in England and Wales was not decriminalised until 1967. Male homosexuality was only decriminalised in Northern Ireland in 1982. And it took until 2000 for the age of consent for same-sex sexual activity between men to be equalised to the age of consent for heterosexual and lesbian, gay, female sexual activity. Section 28 of the Local Government Act 1988 was passed, prohibiting local authorities from intentionally promoting homosexuality and promoting the teaching of it in any maintained school of any acceptability of homosexuality as a pretended family relationship. It was not until 2003 that that was changed, which is quite worrying. Non-discrimination legislation did not cover sexual orientation until the Framework Directive in 2000, and the Employment Equality Sexual Orientation Regulations 2003 were brought into force. The Equality Act 2010 protects, so this is the legislation for England, Scotland and Wales only, discrimination. It covers employees, contract workers, partners and office holders during all stages of the employment relationship. So it's not just when you're in the employment relationship, it's also during the recruitment, the terms and conditions that are offered, promotions, transfer, dismissals and training. Just looking at the Equality Act. So prior to the Equality Act, there was various strands of discrimination law that the Equality Act consolidated and brought into one piece of legislation. So for myself as a practicing solicitor of some time, I had been looking at the various separate legislations. So it was helpful to harmonise the terms and have the legislation consolidated to make it more I wouldn't say user-friendly, you've still got to look through the various forms of discrimination, but what it brought together was the Sex Discrimination Act, the Equality Act, Race Relations, Disability, Religion and Belief Regulations, the Sexual Orientation Regulations, Age Regulations, the Equality Act 2006 and Gender Recognition Act. You'll notice that I've highlighted in bold, I've flagged the Employment Equality Sexual Orientation Regulations and the Gender Recognition Act 2004, because those are the pieces of legislation that we'll be looking at, even though it's part of the Equality Act now. Okay, so what the Equality Act did with those various strands is introduce the concept of protected characteristics. And these are age, disability, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, sexual orientation and gender reassignment. Again, the reason I've flagged those is because that's what the talk will start focusing on after I've provided the background as to where we were with legislation. But I am going to just touch on the point of marriage and civil partnership. Gay men in civil partnership must not be treated less favourably to heterosexual married workers in terms of, well, it wouldn't be simple things, it would be things such as benefits in the workplace, there should be equal treatment, survivors' pensions, staff concessions for family members and health insurance and promotion. I'm touching on marriage and civil partnership here because we're not going to be talking about that further on in the presentation. So what the Equality Act also introduced was the bringing the various forms of discriminatory conduct into this. It's referred to as prohibited conduct. So prohibited conduct I've listed in the separate forms, which is direct discrimination under section 13, indirect discrimination section 19, harassment section 26, victimisation section 27. We're not going to talk about disability discrimination, but I've put those in there because it is part of the prohibited conduct under the Act. But we will talk about discrimination based on association or perception. So sexual orientation, which touched on, means a person's sexual orientation towards another. So sexual orientation means a person's sexual orientation towards persons of the same sex, persons of the opposite sex, or persons of either sex. So the explanatory notes of the Equality Act 2010 confirm that this section provides protection for gay men, lesbians, bisexuals, heterosexuals. They are covered by the protected characteristics of sexual orientation, even though it's not said in the actual section 12.1, it's the explanatory notes that confirm that. Yeah. Sex is a protected characteristic of the section 11 of the Equality Act. There is currently no definition of sex within the Equality Act. However, section 2121 of the Equality Act defines a male as a male of any age and a woman as a female of any age. Sexual orientation is the umbrella term that encompasses sexual identity, attraction and behaviour. It may change over time and in different contexts. Sexual orientation is not a choice. Human sexuality is a wide spectrum, ranging from exclusively heterosexual through to varieties of bisexual to exclusively gay. some people resist labelling and decline to be identified as being of any particular fixed sexuality. So it comes back to the point I'm making. It's how people themselves want to be referred to as, that will sit comfortably with them and avoid them feeling discriminated against. So gender reassignment, a person who is undergoing, so this is the legal definition in section 7 that I'm moving on to, a person who is undergoing, proposing to undergo, or has undergone a process or part of a process for the purposes of reassigning their sex by changing physiologically or other attributes of sex. It is unlawful for an employer to discriminate by treating an employee less favourably in relation to absences from work because of gender reassignment. That's covered under section 16.2. And intersex individuals may also have additional medical needs relating to their condition, which would attract the protection of the disability discrimination provisions within the Equality Act. So just talking about some examples, a transgender worker who seeks to take time off to attend a gender identity clinic as part of their gender reassignment process cannot be treated less favourably than they would treat an absence due to illness or injury. For example, of that would be paying them less than they would have received if they were taking time off for a cold or flu. A transgender worker who informs the employer that they're undergoing gender reassignments may ask for an afternoon off to attend counselling and understands there's sufficient cover for the employer to agree that, and has agreed that for heterosexual staff members. The refusal could, if they refuse to allow them that time off, amount to gender reassignment discrimination. So it's looking at what's happening in the workplace, how employers are treating others, that will give you the evidence to suggest or state quite clearly that you have been discriminated on the grounds of gender reassignment. Okay. I'm going to talk about the Gender Recognition Act 2004. This enables the birth certificate of a transgender person to reflect their genuine gender. The requirements are, in England, they must be over the age of 18. The application must be supported by medical evidence of a diagnosis of gender dysmorphia, proof that they have been living in their preferred gender for the last 2 years. The certificate, or the absence of the certificate, does not impact on the protection under the Equality Act 2010. A person should never be asked to produce their certificate as evidence of their legal gender. It is a criminal offence to disclose without the permission of the person's consent that they have the information that has been obtained in an official capacity. Official capacity can include recruitment process. The Government's Equality Office commenced a consultation. It actually commenced in 2018 in terms of looking at how they could improve the existing legislation. There was some hope that things would improve, but unfortunately they did not, because they reported in September 2020 that a balance had been struck in that the Act was correct with proper checks and balances in place. And they stated that they wanted to make it kinder and more straightforward, simplify the process. So they moved the process online, and the fee from £140 was reduced to £5. And they also stated they would improve healthcare provisions. And by opening, what they said at the time was at least 3 new gender clinics, which would improve the patient care for transgender community with shorter waiting times, better geographical coverage and easier access. The response from the LGBTI community to that was that it is intrusive, the legislation is intrusive and humiliated. It is the step of having to obtain medical evidence to support the diagnosis of gender dysmorphia. As you can imagine, anybody that's having any kind of medical treatment would not want to be sharing that information, particularly to be recognised in the gender that they identify with. The legislation is outdated. Similar criticisms have come from the organisation Stonewall that I've already mentioned to you. Mermaids is a further organisation that campaigns for the LGBTI community, particularly the under 18s. And Susan Green, the charity CEO, added that they were very disappointed with the government's lack of reforms. So she talks about reforms. There's no mention of non-binary identities and falls short of self-declaration. A move which would have brought England and Wales in line with Republic of Ireland, where society has benefited from the demedicalisation system of gender recognition since 2015. So we are behind, and it is disappointing, but that's different. It is disappointing in England. We look to Scotland, where they have better protection in terms of the process for gender reassignment that was set out in the Gender Recognition Bill. What Scotland did was remove the requirement for a psychiatric diagnosis of gender dysmorphia in order to obtain the certificate. It allowed an individual with a Scottish birth certificate or who was ordinarily resident in Scotland to self-certify. There's a big difference between what's happening in Scotland, or what they intended to happen in Scotland and England. And so that in Scotland, once they self-certify, after living in the acquired gender for 3 months, they extended the right to apply for the certificate to from 16 to 17-year-olds after they have lived in the acquired gender for 6 months with a 3-month reflection period. So it's all looking positive. Then, with the Scotland Act 1998, Section 35, the UK government blocked the bill from receiving royal assent. The First Minister is saying that they find the Parliament's actions unacceptable and will still try and push ahead with the changes more likely to be judicial review. But the reason why there is a block on allowing it to become, for it to be enforced, is an argument that it will damage existing legislation, such as the Equality Act, equal pay. Some campaigners are concerned that by allowing anyone to self-identify as a woman could impact on women's rights, that women have fought for these rights for many decades, will impact on equal pay legislation in terms of a relevant comparator. Other criticisms are in terms of single-sex spaces and services. It was also reported that the UK government had concerns about the safety issue of women and children in hospitals and wards, and refugees. So that's where the challenge comes from. Ireland made similar changes and benefited from the, as I've already mentioned, the medicalised system in 2015 without any real issues, and have granted an average of 115 applications per year up to 2020. So that's where we are with our debate and our push for that change to be made. So the idea of the legislation is to support the LGBTI community by eradicating discrimination. And I've put some bullet points there as to how that could be achieved. They're just a summary in terms of the employment relationship. So in terms of recruitment practices, shortlisting and interviews, to encourage applicants from the LGBTI community, positive discrimination, terms set out within the offer of employment, particularly if a person is transitioning and how much time they will be allowed off to transition. It could be somebody who's returning to work after transitioning, how they want to be identified, how they want to be referred to, what are the pronouns. There may be a temporary change to their role. If they should want that, it should never be enforced. There should not be any kind of refusing or deliberately omitting to offer employment. That would clearly be discrimination if we could support that with evidence. There should be access to opportunities for promotion, transfer and training, or other benefits and facilities. And clearly there should never be dismissal or any other detriment, but that's what we would look for in terms of establishing if we thought there was acts of discrimination and how we could take lawful action to stop that taking place by the employer. Okay, so an earlier slide I set out the prohibited conduct. The first one we're going to look at is direct discrimination, which is section 13 of the Equality Act. I've just realised the time, so I'm going to have to speed through some of these. So the example I give is an employee claiming direct sexual orientation or gender reassignment discrimination needs to show that they've been treated less favourably. So they need a comparator. It can be real or hypothetical. An employee claiming direct sexual orientation discrimination will need to show that they have been treated less favourably than a real or a hypothetical comparator whose circumstances are not materially different to theirs. The relevant circumstances are those factors which the employer has taken into account when deciding to treat the claimant as it did, i.e. less favourably, with the exception of their sexual orientation. And the same for the appropriate real or hypothetical comparator in gender reassignment discrimination claim brought by a transgender person is someone whose relevant circumstances are the same as or not materially different to those of a transgender person, but who is not proposing to undergo or is undergoing or has undergone gender reassignment. Okay, so we're looking at direct discrimination. Direct discrimination also covers discrimination by association or perception. It's not just limited to claims based on the complainant having a protected characteristic of gender reassignment or sexual orientation. A cisgender person can bring a claim, which is sometimes overlooked. So where, for example, B claims that A has discriminated against B because B has or is perceived to have lesbian, gay, bisexual or transgender friends, the comparison will be with someone who does not have lesbian, gay, bisexual or transgender friends. Direct discrimination cannot be objectively justified, but there is the exception of occupational requirements such as religion. So where we've got organised religion, employment for the purposes of that, an employer can apply an occupational requirement for an employee not to be transsexual in order to comply with the doctrines of the religion. It could be anybody from the LGBTI community, as it might, to avoid conflicting with the strongly held religious beliefs of a significant number of religious followers. So the next slide is on comparators. I've jumped a slide there. So an employee claiming a direct sexual orientation, gender reassignment, needs to show that they have been treated less favourably than the comparator that they've identified. A worker claiming direct sexual orientation will need to show that they've been treated less favourably than that comparator in the circumstances are those which the employer has taken into account when deciding to treat the claimant as it did, with the exception of the sexual orientation. As I mentioned on the earlier slide, the same test is applied for the hypothetical comparator in gender reassignment discrimination in claims brought by a transgender person is someone whose relevant circumstances are the same or not materially different to those of a transgender person, but who's not proposing to undergo or is not undergoing or has undergone gender reassignment. However, the Equality Act is not limited to claims only on the complainant having a protected characteristic, where, for example, B claims that A has discriminated against B because B has lesbian, gay, bisexual, transgender friends or companions. The comparison should be with someone who does not have that comparison. So I was trying to reinforce the earlier point, but I think the next slide will give more information as to how that works in reality. So in the first case of Twine Primary School governing body, there had been an investigation into the gay head teacher's sexual life outside the school, and there was no criticism of that teacher. The investigation officer who looked into the disciplinary allegations had displayed a striking lack of objectivity in his approach, assuming that child protection. So the first investigation was a safeguarding investigation. The head teacher was exonerated. It was the internal investigation that was said to be tainted with presumptions about well, there was a lack of objectivity, which made the disciplinary investigation flawed, which obviously worked for our members in our members' favour. Refusal to employ a gay couple. So this was a pub who would not employ a gay couple as they felt it would be disastrous for their business, even though the gay couple were well experienced in that area of work. The next case, Hegarty, was a gay bar where they dismissed a heterosexual woman. So this legislation does protect heterosexual people. It was found to be discriminatory because the reason provided as redundancy was not supported by the evidence. And then we've got Croft, the case of Croft related to the use of single-sex facilities, toilets. And I know this is a big issue for a lot of caseworkers. It was decided before the Equality Act and the Gender Recognition Act. So no medical intervention is required by the Equality Act. The transgender woman had not undergone surgery, but was prohibited from using the female toilets, and it was originally agreed that she would use the disabled toilet, but brought a claim due to delay. It's not the current up-to-date law, but it was worth mentioning because it's the leading case. The issue in terms of addressing single-sex facility is proportionality. There should not be a blanket response as to you can or cannot. It is unlawful to expect a transgender person not to use facilities that heterosexual people can use. There has to be a blanket policy either way. Single-sex facilities is probably the way forward, but there are subtle differences, such as if there is a communal area in any change in facilities, there might be grounds to suggest that a transgender person may want to use separate facilities within that facility. But that will be a careful discussion. It should be approached with caution. So moving on to failure to investigate harassment, the leading case on that is NASUWT. And it was a case of Primark had failed to look into the complaint, which then led to a claim of discrimination. The case of AB versus Royal Borough of Kensington is looking at dead naming. That is the name that was used at birth by a transition person who does not want to be using such a name. And in that case, despite the transition person notifying their employer, there was a very big delay in them changing the internal records, including emails and correspondence, to the point they'd left a note on the locker with the dead name being crossed out with the transition name. Clearly, that's not acceptable. Gender critical beliefs will be found to be discriminatory, and they can't be enforced against the LGBTI community. In Bull, accommodation was refused to a gay couple. It was before the update of the law, by refusing a homosexual couple who were in a civil partnership. The owner said that we wouldn't let anybody who is not married live there, so we're not discriminating against the homosexual couple. But this was before the change in legislation where they could have a civil partnership. The bakery case is quite a familiar case. It's where they did not want to, it was a Christian bakery. The Supreme Court held that there was discrimination because they did not want to support the caption and support gay marriage, which was a requirement that they should have met. Indirect discrimination is where there is a blanket policy applied to everybody, but those of a particular characteristic of gender reassignment and sexual orientation are disadvantaged by the application of that policy. There is the justification defence, which has to be genuinely, there has to be a genuine defence. It cannot just be something that is used but not explained. And the next example highlights that. So this example shows that as part of a team building exercise, the head teacher decides to invite all staff members to bring in a picture of themselves when they were at primary school. No, the transgender teacher does not want to disclose that they were brought up as a boy in front of colleagues, and the head teacher in front of colleagues on the day in question during the ice-breaking activity shows their annoyance that this transgender teacher has not brought in the picture. It does not matter what the head teacher's intentions are. Obviously, the head teacher wanted to make sure that there was an open discussion about teachers' experience and how they want to improve, but that would not be enough to remove that argument that it wasn't unlawful discrimination. So just touching on harassment occurs where there's unwanted conduct which violates a person's dignity, and the full definition is there. It talks about related to, so it does cover association and perception. So an example here is to out someone as gay is to make reference to them as gay is harassment. There's a case there. There is a defence, but it has to be carefully applied, which looks at the complainant's perception of it, other circumstances, but whether the complainant's perception was reasonable. And then we're looking at victimisation. Victimisation occurs when somebody has done an act, a protected act, brought proceedings or supported somebody, and because they've done that protected act, they've been victimised. Victimisation can be post employment in terms of withholding a reference because the person may have taken proceedings themselves or supported somebody who took proceedings. So victimisation can occur in this example where there's a sports day and everybody is encouraged to bring their family and friends. And again, head teacher might have found out that a staff member is going to bring their partner who's from the LGBTI community. And there is a complaint submitted and upheld. So there is legal action taken and it's upheld. Later, it transpires that this individual is excluded from school trip, and there's rumours that it is connected to their association or perceptive association, or even their actual association with the LGBTI community. That will be an act of victimisation because they have suffered a detriment as a result of being a member of the LGBTI community or associating with it. In terms of support, I've set out on this slide the support that can be provided to the LGBTI community. And there is the public sector duties, which must look at eradicating discrimination, all forms of discrimination. And if you're looking at maintained schools, they are obliged to follow that duty. You can have positive discrimination under the Equality Act, generally for disadvantaged groups such as those that belong, that have sexual orientation or gender reassignment as their protected characteristic. And that includes recruitment. They can be, the person can't be less qualified. They should have the attributes to complete that role, but there can be some positive discrimination in terms of determining who gets that role. Setting up representatives of the LGBTI community to make the organisation more inclusive. Focusing on equality and inclusion policies. There is the employment, the equality, sorry, I'll get my abbreviations right, EHRC, Employment Statutory Code of Practice guidance that should be looked at. It is a good read from my point of view. It's a good read in terms of if you're struggling in terms of determining whether something is discriminatory or not. It's a good source of information. We've already talked about gender neutral toilets, gender neutral dress codes. That should be improving. Employers are getting better. They should not insist that staff wear certain items. Skirt is a good example. If a cis woman is wearing a skirt, there's nothing to prevent a transgender person or someone with certain sexual orientation from wearing that skirt. Forms should have gender options, pronouns. We've already touched on transitioning, improving leave allowance when transitioning. I'm just going to round this up because I'm conscious that I've run over and I've had to rush through the slides, but I'm just going to talk about where it takes us in terms of if we do have sufficient evidence. And that is a big obstacle in itself. And I think this is where your role is quite crucial in terms of the person who's been discriminated against will come to you as the first port of call. And it's what happens at the early stages that will really make and break the employment relationship. If it can be resolved at an earlier stage, then that is usually for the benefit of all. From the claims that we've had into the legal team, there hasn't been many. It's probably one that trickles through a year. There's one that I'm thinking of in particular that settled in an early stage, an early conciliation stage, which I'll mention what that process is. For a substantial sum of money, we've had advice requested from the legal team in terms of religion, which can have an overplay on sexual orientation. But the burden of proof is originally with the complainant. They would have to say, because this has happened to me, I believe I've been discriminated against. The burden then shifts to the employer. And if the employer cannot show that they haven't taken sufficient steps, even for someone they employ, to have prevented the discrimination, then they will be liable for themselves and vicariously liable for that person. A way to collect information is through the ACAS questionnaire procedure, where you can ask certain questions, but there's no obligation on the employer to answer those questions. But the fact that they don't answer those questions can lead to an employment tribunal judge drawing an inference as to why that question wasn't answered. They shouldn't be abused. They should be used appropriately, because if you put questions in there asking them to admit guilt, they're unlikely to answer them. They have to be coached. The wording of it has to be coached very carefully, and they shouldn't be too long. They should get to the point. But if a claim is getting to that stage, you will have transferred it up to regional centre colleagues who are very experienced at looking into these matters and have certain guidance from legal, and will liaise with us in terms of progress in that case, because we want to help that individual. Time limits, a very important point. It's 3 months of the Discriminatory Act. With discrimination cases, it's from the Discriminatory Act. It's unlike unfair dismissal, where the time limit runs from the date of dismissal. It will be from the Act. So the member might not be dismissed for a few months after the actual Discriminatory Act. There may be more than one act. If they're close in succession and connected, we could argue it's the last of the series of those acts. But the safest approach is when a member is speaking to you and saying, I believe I've been discriminated against on the grounds of my sexual orientation or gender reassignment. Think of the date they say that incident took place, and action has to be taken from that date. Early conciliation is a process that must be triggered before we can go to the employment tribunal. That, again, has to be triggered within 3 months of the act complained of. It's a straightforward process. Regional centre colleagues are very experienced on triggering that. It can be completed online. No obligation on either party to engage. It's best if they do, to protect the employment relationship. Remedies at the employment tribunal include declarations that they have been discriminated against, recommendations that can be made to the employer. Compensation can include loss of earnings, and then usually with discrimination cases, we rely on the Vento guidance that determines injury to feelings, which is a figure of compensation that is connected to discrimination claims. I've put the bands there. There are 3 bands. There's a lower band, the middle band, and the upper band. The lower band is usually for a one-off incident, a middle band for those that don't fall into the more serious categories, not that we want more serious categories. And then we have the upper band. Compensation is unlimited. But when we talk about injury to feelings, which is the compensation for discrimination claims, it is those bands. Right, I've got to the thank you slide, so I'm going to stop sharing my screen.
Thank you, Suki. We've just got 5 minutes left, and there have been a couple of questions in the Q&A box and just one in the chat box. The Q&A, there's one query, I think, and I'm not sure which slide they're referring to, but it says that there was a phrase used, actual gender, was mentioned on a slide, and said it's not clear what that refers to. So I'm not sure if you can kind of look back and see what the context was. What the context was for using that term, actual gender, because
gender identity is personal to an individual, is the point I was making. So throughout this, I started by talking about terminology. The terminology I use may not sit comfortably with the audience because they might not identify with the terminology I'm using. The terminology I then went on to use is the legal terminology, and it's not good. It's recognised the terminology within the Equality Act needs to be modified and updated. It's out of date. We still hope it will be. When it will be, we don't know. What I should have also mentioned, I'm sorry for moving on to another point, but I know we're running out of time, is that we're still waiting for government guidance. I spoke to the education team, Darren in particular. There is guidance that we're waiting to be issued by the government that will clarify a lot of terminology and support the leadership team, head teachers that are trying to do the right thing but may not be able to do the right thing because they haven't been given the appropriate tools. So at the moment, we're just using what we have. I hope that's answered the question that you were raising in terms of gender identity.
Yeah, and that kind of answers the second, and another one's just come in around gender and again sex, and it needs to be clear that it is very complex when we're talking about gender, and it's very fluid, and you're quite right. There are legal terms. When we're talking about sex, it is legally a biological term, and it is a binary term between a man and a woman. Within the law, there are no provisions for non-binary at the moment. That's something that we, along with other trade unions and bodies, have lobbied for. When we're talking about gender, it's very much around the social construct and the sense of self, and how you see your own
With
gender.
transgender person, a transgender individual, it's from the moment they have the intention that they are covered by the protection. They don't have to have taken, not have undergone any medical intervention. It's from the point they have the intention to transition.
Absolutely. And in the last, there's a question from Delma who's got a particular case of an LGBT member said who's been hassled on the street and in school, basically saying that he's gay, and it's impacting on their members' health and well-being. What can the NASUWT do? So we can absolutely do something to support. If it's happening in the workplace, so what advice would you give to Delma then with this member?
Right, at the moment, it's getting a clear record of what the complaints are, and it's the bell that always rings in my mind is, when did it happen? We've got 3 months to be taking action. We've got to be taking action. At the same time, you've got to be building that evidence trail as well, making sure the members recording it, keep a diary, any incidents that are happening. We need to connect them. So we're looking at the employment relationship when we've done this webinar today. What's happening in the workplace? What policies are in place? Is the employer looking after this member? Are they applying the policies? If they're not applying the policies or they don't exist, we need to know why that has happened. But the main point to take away from this is time limits. You need to refer it onto the regional centre as well as supporting locally, but we need to start looking at that claim. It will be a case of raising a grievance and making sure the employer addresses those concerns. But the grievance is a separate issue. By raising a grievance, you're not pausing the clock for a tribunal claim. So don't mix up the two. You can carry on with the grievance. Sometimes you can lodge an employment claim to make sure you're not time barred.
Well, that's helpful. The Delma's in Northern Ireland, so obviously you should raise it with the Northern Ireland Centre, but whether this needs to be a grievance.
I mean, the Northern Ireland colleagues are dealing with a case at the moment that we've had a reasonable outcome, so they will support you with that.
Okay, that was wonderful. Thank you so much, and thank you to everyone for participating this afternoon, and for those who have put their questions in. As I said, this will be recorded and put on the website probably in the new year. And if you are an accredited caseworker, this will act towards your accreditation. As long as you have registered and completed the whole of the webinar, then this can be included. So hope to see you at any future webinars. Again, thank you, Suki, for an excellent thing. You got through a lot in a very short amount of time.
I think I tried to cover too much, but on the supply teachers question, yes, they are covered.
Absolutely. It's regardless of the nature of your employment, you are covered under the Equality Act or equivalent. So thank you very much, everyone.
Thank you for joining.
Have a great weekend.
Thank you. Bye-bye.
Okay.